Thank you, Cosmin. First of all, I would like to thank the Foreign Minister and the organisers of this conference for inviting me to this event and to speak today. It's a real pleasure to be back here in Bucharest. On a personal note, as Bogdan said, maritime delimitation in the Black Sea was also my first case before the ICJ, and it was the occasion of my maiden speech before the court. And as I recall, the request, or rather the order to speak during the second round came rather late in the day, and it resulted in a certain number of sleepless nights. But nevertheless, I have very warm memories of both the experience and of the camaraderie among the team. I've been asked to talk about the two interpretation of peace treaties advisory opinions from 1950. First of all, two health warnings. First, as will become clear, there is not a great deal to say about Romania's involvement in the case. And so what I will say about Romania will be relatively limited. And second, the title on the program is somewhat misleading. I won't be focusing exclusively on interpretation and revision, although I will say something on that point. Rather, I'll try to give a more general assessment of the continued importance and relevance of the two advisory opinions. Before turning to those points and attempting to assess the legacy of the advisory opinions, I want to retrace briefly the circumstances which led to the request addressed to the International Court of Justice and Romania's involvement in that process. To set the scene, as the title of the case suggests, the two advisory opinions relate to the interpretation of the peace treaties with Bulgaria, Hungary, and Romania, which were concluded in 1947 following the end of the Second World War, when the three states had been subject to Soviet occupation and sympathetic regimes had been installed. The three treaties were for present purposes similar. First, each took the form of a multilateral treaty between, on the one hand, the defeated states, and on the other, the Allied and associated powers. Second, each contained a provision in materially similar terms, which provided that the three states would take all measures necessary to secure to all persons under their respective jurisdiction, without distinction as to race, sex, language, or religion, the enjoyment of human rights and of the fundamental freedoms, including freedom of expression, of press and publication, of religious worship, of political opinion, and of public meeting. Finally, each of the treaties also contained a dispute resolution mechanism applicable to any dispute concerning the interpretation or execution of the treaty. And it was in relation to this dispute mechanism that the advisory opinion was requested. The procedure envisaged in the first instance the reference of the dispute to the heads of mission of the US, UK, and Soviet Union. Thereafter, in the event the dispute was not resolved by the three heads of mission within 2 months, the dispute could be referred by either party to a commission composed of one representative of each party and a third member selected by mutual agreement of the two parties from nationals of a third country. In the event of a failure to agree within 1 month upon the appointment of the third member, the appointment of the third member was to be made by the Secretary General of the UN. The two interpretation advisory opinions concern a series of relatively dry and abstract legal questions, to which I'll come in a moment. As I've said, they relate precisely to the interpretation and operation of the dispute resolution mechanisms. However, the background to the dispute is of somewhat greater interest, insofar as it constitutes but one chapter in the early Cold War struggle of the UN between the West, in particular the US and the UK, and the Soviet Union and its satellites. And certainly it forms part, and is, I think, indissociable from the admissions cases. It is also of interest for the way in which the situation was carefully engineered by the US and the UK. As to Romania's involvement in the case, obviously it constituted, as it were, one of the objects of the request for the advisory opinion, in the sense that it was party to one of the peace treaties which the court was called upon to interpret, and also one of the states charged with violation of those treaties. It is interesting to note, however, that at least in terms of the General Assembly's consideration of the issue, Romania was added relatively late in the day, and the initial focus was on Bulgaria and Hungary. In large part, it seems that the initial trigger for reference of the matter to the General Assembly was the trial of religious leaders in Hungary. In that regard, by a letter from Bolivia, dated the 16th of March 1949, it requested the inclusion on the agenda of the specific issue of legal proceedings against Cardinal Mincenci, the Archbishop of Esztergom and the Catholic Primate of Hungary, who had been tried, convicted, and imprisoned earlier in 1949. A few days after the Bolivian letter, on 19th March 1949, Australia sent a letter which requested the inclusion on the agenda of the wider question of, and I quote, observance of fundamental freedoms and human rights in Bulgaria and Hungary, including the question of religious and civil liberty in special relation to recent trials of church leaders. The matter was considered in the second part of the third session in 1949 in the General Assembly, and the agenda item was allocated to the Political Committee, which considered the matter during the course of April 1949. Bulgaria and Hungary, supported by the Soviet Union, disputed the competence of the General Assembly to take up the question, on the basis that it involved interference in their domestic affairs contrary to Article 2.7 of the Charter. So at that point, the matter still related solely to Bulgaria and Hungary. However, in the meantime, the US and the UK, supported by Australia, Canada, and New Zealand, had on the 2nd of April 1949 written not only to Bulgaria and Hungary, but also to Romania, formally charging them with various violations of the human rights provisions of the peace treaties. And although the documents which were before the court effectively start with the 2nd of April letter, it appears that previous letters had been written in relation to alleged violation of the peace treaties and respect for human rights. Each of the three states responded during the course of April 1949, denying the charges leveled against them. They denied that there in fact existed any dispute in that regard, and charged the US and the UK with attempting to interfere in their domestic affairs. On the 30th of April 1949, the General Assembly adopted Resolution 272, by which, and I quote, it expressed its deep concern at the grave accusations made against the governments of Bulgaria and Hungary regarding the suppression of human rights and fundamental freedoms in those countries, took note of the steps taken by certain signatories to the peace treaties, and drew the attention of the two states to their obligations under the peace treaties. That resolution was adopted over the protestations of Hungary and Bulgaria and the Soviet Union and associated states that, under Article 2.7 of the Charter, the General Assembly had no competence to consider the question as being one within their domestic jurisdiction. On the 31st of May 1949, the US and UK noted that, in light of the responses, they considered that a dispute had arisen in respect of the obligations under the Treaties of Peace, and they invoked the dispute resolution procedures, indicating that they were referring the disputes to the heads of mission. On the same date, the US and the UK also wrote to the USSR seeking to convene a meeting of the heads of mission. Predictably enough, the USSR, in its response on the 11th of June 1949, took the position that the governments of Bulgaria, Hungary, and Romania had provided an exhaustive reply to the charges against them, and that it was evident the governments were strictly fulfilling their obligations under the peace treaties. They likewise took the position that the US and UK were attempting to use the peace treaties to interfere in their domestic affairs. On the 1st of August 1949, thereafter, the US, UK, and Canada sent note verbale to the three states, noting that the Soviet ambassadors in each of the three states had made no reply to their letters, that the USSR had made clear that it saw no reason to convoke the heads of mission, and that the period of 2 months foreseen by the peace treaties had passed without any resolution of the dispute. And on that basis, they invited the three governments to join in the appointment of the commissions foreseen by the peace treaties. The three states responded in similar terms, inter alia again denying that there existed any dispute as to the observance of the peace treaties. And it was only at this point, following an Australian proposal in a letter dated the 20th of August 1949, that an additional item should be added to the supplemental agenda for the fourth session, relating to the observance of fundamental freedoms and human rights in Romania, including the question of religious and civil liberty, that the question of Romania's compliance with its obligations under the peace treaty was added to the agenda item before the General Assembly. Thereafter, the question was again considered in the political committee at the fourth session during the autumn of 1949, and that consideration resulted in the adoption of the request by the General Assembly for an advisory opinion on the 22nd of October 1949 by Resolution 294. Finally, in order to complete the picture, on 5th of January 1950, whilst the request for an advisory opinion was pending, the UK and US appointed their members of the treaty commissions. Turning to the request and the advisory opinions themselves, by Resolution 294, the General Assembly decided to request an advisory opinion on 4 questions, each of the second to fourth questions only arising in the event of an affirmative answer to the preceding questions. Unsurprisingly, given that the peace treaties contain specific mechanisms for resolution of disputes relating to their interpretation and observance, the questions crafted in the General Assembly and included in the request were deliberately abstract and focused on questions of interpretation on the procedural obligations relating to dispute settlement, rather than with the various substantive allegations of violation of the human rights provision in the peace treaties. In summary, the first question asked whether the diplomatic exchanges between each of Bulgaria, Hungary, and Romania, and the US and the UK on the other, in relation to compliance with the human rights provisions of the peace treaties, constituted disputes falling within the dispute settlement provisions of the peace treaties. The second question asked whether, if that was the case, the three states were obliged to comply with the relevant provisions, including by appointed representatives to the commissions. In the event of an affirmative question to the second question, and if the three states had not appointed their representatives to the commission within a period of 30 days, the ICJ was asked to go on to consider 2 further questions. Third, in the event one party failed to appoint a representative to the treaty commissions, was the Secretary-General authorised to appoint the third member upon the request of the other party? And fourth, if so, would a treaty commission so composed constitute a commission with the meaning of the treaties, competent to make a definitive and binding decision in settlement of the dispute? So, it's useful briefly to summarize the submissions by the three states prior to going on to consider the court's actual answer to the questions. Each of Bulgaria, Hungary, and Romania limited themselves to very short submissions. That of Bulgaria was transmitted by telegraph, and those of Hungary and Romania being transmitted by short, two-page letters. Those submissions raised substantially the same points. The three states by this stage had dropped the suggestion that there existed no dispute within the meaning of the dispute resolution provisions. Rather, they likewise disputed the competence of the General Assembly to consider the matter, and therefore to request the court to give an advisory opinion, and also disputed the competence of the court to consider the matter without their consent. In addition, in various forms, they noted that they had not become members of the UN and were not party to the statute of the court. And in the position taken, they were supported by the Soviet Union and other states from the Eastern Bloc. None of the three states addressed the merits of the specific questions on which an advisory opinion had been sought. So I'll briefly summarize the court's answers to those questions posed before seeking to identify what I think are the points which remain of interest from the court's advisory opinions. The court's response to the first two questions, both of which are answered in the affirmative, are of relatively little interest, and indeed are relatively self-evident given the facts. As to the first question, the court considered that the matters contained in the diplomatic exchanges did indeed constitute disputes, and that those disputes fell within the meaning of the dispute resolution provisions. As to the second question, the court was similarly brief. The court took note of the failure of the three-head submission to resolve the dispute within the stipulated time, and the request by the US and UK to settle the disputes by convening the commissions, and noted that all the commissions required for the commencement of the stage of settlement by disputes by the Commission have been fulfilled. And on that basis, the court held that in light of the fact that dispute resolution provisions provided that any dispute could be referred to a commission at the request of either party, it followed that, and I quote, either party is obligated, at the request of the other party, to cooperate in constituting the commission, in particular by appointing its representative. Following the first phase, no appointments were made, and the court therefore took up the third and fourth questions. In response to the third question, the court answered in the negative and held that the Secretary-General couldn't appoint the third member of the commissions in the absence of appointment by one of the parties. As a result, the court considered that it was not obliged to answer the fourth question as to the validity of a commission consisting of only of one party-appointed commissioner and a commissioner appointed by the Secretary-General. Nevertheless, it may be noted that the response to that question results relatively clearly from its reasoning in relation to the third question, and in particular its observation that, and I quote, a commission consisting of two members is not the kind of commission for which the treaties have provided. Turning to assess the advisory opinions, as an application of the principles of treaty interpretation, the court's conclusions on the three questions are relatively unexceptionable. They concentrate principally on the natural and ordinary meaning of the words used in the peace treaties. Further, the response to the third question and the particular result of the case, resulting in the de facto blocking of the arbitration mechanism foreseen by the peace treaties, has to a large extent been rendered irrelevant by subsequent developments, and indeed may be seen as playing a role in triggering them. These developments have seen a growing willingness, at least in a multilateral context, to provide expressly for the consequences of the failure of one party to appoint an arbitrator, so as to prevent precisely this type of frustration at the threshold of the arbitral process. The examples that can be given are numerous. Prime examples are constituted by the provisions for appointment of arbitrators in default by the President of ITLOS under Articles 3b to E of Annex 7 of UNCLOS, as recently put into action in the Philippines versus China and Netherlands versus Russia arbitrations, and also in Articles 6 to 10 of the PCA's 2012 arbitration rules and Articles 6 to 8 of the PCA's optional rules for arbitrating disputes between two states. A further example in a slightly different context is the provision in Article 38 of the Exit Convention, which permits the Chairman of the Administrative Council to make such appointments as are necessary to complete an arbitral tribunal if it is not constituted following the expiry of a period of 90 days from registration of the request for arbitration. Finally, under more general application, there are the 1976 and now 2010 UNCITRAL arbitration rules, both of which, in default of an appointment, confer power upon an appointing authority to constitute the tribunal, and in the latter case, provide, if necessary, elaborate default provisions for the selection of an appointing authority. There are three aspects, I think, of enduring relevance. None of them as such relate to the specific questions posed to the court. First, in the context of its discussion of the third question in its opinion on the second phase, the court recalled that it had found in the first phase that Bulgaria, Hungary, and Romania were under an obligation to appoint their members to the treaty commissions, and added, and I quote, "It is clear that refusal to fulfill a treaty obligation involves international responsibility." That passage forms the foundation for the following passage, which usefully distinguishes international responsibility and breach of treaty from the question of the interpretation of the dispute resolution provisions. In that regard, the court observed that a refusal to appoint in breach of the obligations under the treaties, and I quote, "cannot alter the conditions contemplated in the treaties for the exercise by the Secretary-General of his power of appointment. These conditions are not present in this case, and their absence is not made good by the fact that it is due to the breach of a treaty obligation. The failure of machinery for settling disputes by reason of the practical impossibility of creating the commission provided for in the treaties is one thing. International responsibility is another. The breach of a treaty obligation cannot be remedied by creating a commission which is not the kind of commission contemplated by the treaties." End of quote. Of course, it is arguable that the observations as to international responsibility were not necessary to the court's reasoning and fell outside the scope of the advisory opinion. Judge Krylov, the Soviet judge, dissociated himself from the court's reasoning on those points on precisely this basis, although not as such disputing the correctness of the propositions put forward. Nevertheless, whilst a relatively uncontroversial proposition, the court's dictum that refusal to fulfill a treaty obligation involves international responsibility constitutes a strong reaffirmation of the objective, automatic, and immediate nature of international responsibility consequent upon the breach of any obligation, as previously enunciated by the Permanent Court in the Factory at Horzov cases and repeated by the ICJ in the Reparations Advisory Opinion. It was invoked as such by the International Law Commission in the commentary to the Articles on State Responsibility, including in particular in support of the proposition contained in Article 1 that every international wrongful act of a state entails the international responsibility of that state. The second point of relevance is the court's further epigrammatic observation at the end of the passage just cited that, and I quote, "it is the duty of the court to interpret the treaties, not to revise them." That observation can be generalized and again is far from controversial. Nevertheless, it constitutes a useful and pithy reminder of the permissible limits of treaty interpretation. Obviously, the point at which one tips from the legitimate interpretation of a treaty, however extensive, to its impermissible revision, is a difficult question on which views may differ, and to some extent may be in the eye of the beholder, or potentially in the eye of the minority member of a court or tribunal. Third, and perhaps most importantly, there is the court's consideration of the various objections raised as to its competence to give the advisory opinion requested, and its expansive view of its jurisdiction in that regard, which have shaped the court's subsequent practice. Of course, these are precisely the points on which Romania did make submissions. The first argument distilled by the court from the submissions of Bulgaria, Hungary, Romania, and the other states was that in making the request for an advisory opinion, the General Assembly had acted ultra vires since, and I quote, "in dealing with the question of the observance of human rights and fundamental freedoms in the three states, it was interfering or intervening in matters essentially within their domestic jurisdiction." And that was based on the fact that it was incompetent in light of Article 2.7 of the Charter. The court characterized that argument as based on a misunderstanding. First, it explained, I think somewhat elliptically, that the General Assembly was dealing with alleged violation of the human rights provisions of the peace treaties and had justified the adoption of its resolution on the basis of Article 55 of the Charter, pursuant to which the UN shall promote inter alia respect for human rights. Although in context the point the court was intending to make is not made explicit, it appears to be this passage to which the court was referring when, in its Kosovo advisory opinion, it noted that, and I quote, "the court has sometimes in the past given certain indications as to the relationship between the question which is the subject of a request for an advisory opinion and the activities of the General Assembly." The court then went on to note that the request did not require it to deal with the charges brought before the General Assembly, as the request related, and I quote, "neither to the alleged violations of the provisions of the treaties concerning human rights and fundamental freedoms, nor to the interpretation of the articles relating to these matters." Rather, as the court explained, the object of the request was much more limited, being directed, and I quote, "solely to obtaining from the court certain clarifications of a legal nature regarding the applicability of the procedure for the settlement of disputes by the commissions." And the court continued, "The interpretation of the terms of a treaty for this purpose could not be considered as a question essentially within the domestic jurisdiction of a state. It is a question of international law, which by its very nature lies within the competence of the court." And the court added, without any further elaboration, that those considerations were also also sufficed to dispose of the objection based on the principle of domestic jurisdiction and directed specifically against the court, i.e. that's the argument that the court itself was bound to comply with Article 2.7. Second, the court dismissed the argument that the request for an advisory opinion would take the place of the dispute settlement procedure put in place by the peace treaties. In that regard, it noted that rather than placing an obstacle in the way of that procedure, the object of the request was to facilitate it by seeking information as to its applicability in the circumstances of the present case. Third, in response to the objections based on the opposition of the three states relying on the well-established principle of international law according to which no judicial proceedings relating to a legal question pending between states can take place without their consent, the court held that that argument again was based on a confusion between contentious and advisory proceedings. In this regard, the court emphasized that the requirement of consent, while constituting the basis of the court's jurisdiction in contentious proceedings, was not as such applicable in advisory proceedings, even where those proceedings relate to a legal question actually pending between states. The court emphasized the non-binding nature of an advisory opinion and continued in a passage which is frequently relied upon subsequently. It follows that no state, whether a member of the United Nations or not, can prevent the giving of an advisory opinion which the United Nations considers to be desirable in order to obtain enlightenment as the course of action which it should take. The court's of opinion is not given to states, but to the organ which is entitled to request it. The reply of the court, itself an organ of the United Nations, represents its participation in the activities of the organization and, in principle, should not be refused. This expansive vision of the advisory jurisdiction has since been reaffirmed and elaborated upon in a number of subsequent advisory opinions. In Western Sahara, the court made clear that, and I quote, "The absence of an interested state's consent to the exercise of the court's advisory jurisdiction does not concern the competence of the court, but the propriety of its exercise." The court has also added in later opinions that it will not seek to substitute its own view as to whether the advisory opinion is in fact necessary to the work of the requesting organ, nor the propriety of the motivations behind the request. Finally, in response to the further objection based on the judicial character of the court dismissed suggestions that the circumstances of the case were, and I quote, "of such a character as should lead it to decline to answer the request." The court distinguished the decision of the permanent court in the Eastern Karelia case, noting that in that case the question put to it was directly related to the main point of a dispute actually pending between two states, so that answering the question would be substantially equivalent to deciding the dispute between the parties. By contrast, it noted that the request was solely concerned with the applicability to certain disputes of the procedures under the peace treaties, and suggested that, and I quote, "it is justifiable to conclude that it in no way touches upon the merits of the disputes." Having noted that the commissions had sole competence to rule upon any disputes relating to their jurisdiction, and that the opinion would not prejudge any such objections, the court concluded that the legal position of the parties to these disputes cannot in any way be compromised by the answer that the court may give to the questions put to it. Of course, the questions of whether or not there existed a dispute, and accordingly whether Bulgaria, Hungary, and Romania were under an obligation to appoint their commissioners, were matters which had been very much in dispute, at least in the correspondence preceding the request for an advisory opinion. The fact that those objections had not as such been maintained before the court thus appears to have been of some importance. One may also speculate, however, that the artificiality and weakness of those positions may have had something to do with the court's decision on this point. In conclusion, the major aspect of continued importance of the advisory opinion, I think, results from the court's expansive view of the scope of its advisory jurisdiction and its unwillingness to allow objections by states whose interests might be affected or touched upon by the opinion, so rendered to prevent it from giving an opinion. That approach has laid the foundations for and been relied upon in the court's subsequent practice in those advisory opinions touching upon specific disputes between states, including most notably the legal consequences opinion of 1970, the Western Sahara opinion of 1975, as well as the more recent opinions, most notably the Wall and the Kosovo advisory opinion. Thank you for your attention.